The next session is hosted by Cyril Amarchand Mangaldas. The topic of the session is India's evolving BIT regime, overhaul and stakeholder management. The session is moderated by Abhileen Chaturvedi. The speakers include Gautam Bhattacharyya, Genevieve Poirier, Karan Rukhana, Manish Aggarwal, and Sapna Jhangiani. Thank you.
So the famous COVID dialogue, am I audible? Yes. Yeah. Good afternoon, everyone. A very warm welcome to the session on India and investor state dispute settlement. Uh, ISDS has always been a subject of intense debate, balancing the sovereign right to regulate on the one hand and the protection of foreign investors on the other. India's own journey has been slightly checkered when it comes to ISDS. In the recent times, we've seen various discussions on negotiations of newer BITs, which involve India and other states, as well as regional trade agreements, along with a few FTAs with trade and investment provisions. Uh, we are fortunate today to have a distinguished panel who brings insight from all these angles, who have represented governments, investors, and have been active on the academic side of things as well. I'll introduce them briefly before we dive into the discussion, starting with Mr. Gautam Bhattacharya. Gautam qualified as a solicitor in England and Wales in 1993 and became a partner in ReedSmith in the year 2000. He served as the founding managing partner of the firm's Singapore office from the year 2012 to 2015 and was a member of the ReedSmith Global Board, its executive committee from 2017 to 2023. Gautam has extensive experience of acting in international arbitrations under the rules of the ICC, UNCITRAL, LCIA, SISC, ICSID, and the Stockholm Chamber of Commerce. He has also conducted numerous litigations before the English courts, as well as cases involving the courts of many other jurisdictions. Gautam is regularly ranked in number of legal rankings and is highly recommended for litigation and arbitration. Interestingly, Gautam was part of the representative teams acting on the first set of treaty arbitrations invoked against the government of India after disputes arose concerning the Dabhol power project. Next, we have Miss Genevieve Poirier. Genevieve specializes in international arbitration and litigation, acting both as counsel and as an arbitrator. As an advocate, she brings deep expertise in resolving high value cross border disputes across sectors, including telecommunications, energy, infrastructure, and financial services. Admitted to practice in New Zealand and England and Wales, she has gained significant experience with India seated and India related arbitrations and draws upon her work with all major institutions and arbitral seats, including London, Paris, Geneva, New York, and Delhi. She's praised across directories for her collaborative style and for navigating complex matters with strategic finesse. Next, we have on the panel is Mr. Karan Rukhana. Karan is an independent advocate and a counsel associated with the chambers of senior advocate Mr. Darius Khambata. He participates in commercial and constitutional matters before the Bombay High Court and the Supreme Court of India. In addition to his experience, his experience also includes participating in domestic and foreign seated commercial arbitrations related to joint venture and mergers and acquisitions disputes. He is licensed to practice in New York and in India. Karan holds an LLM from the Georgetown University Law Center and is currently pursuing a PhD from the University of Geneva, from the University of Vienna. His research focuses on the convergence of investment arbitration, climate law, and quantification of damages. Karan is also a regional representative for Young ICA. We also have Manish, who's a partner at Three Crowns and head of its India practice. He has extensive experience of representing clients in commercial and investment treaty arbitrations across a broad range of sectors and in arbitration related court litigations. Manish is consistently ranked as a leading practitioner in arbitration and public international law by major legal directories and is among a few selected arbitration practitioners who are recognized in Who's Who Legal Thought Leaders, Global Elite, and Global Arbitration Review 45 under 45 lists. He has also been recognized in the India Business Law Journal's list of top international lawyers for India related matters. Our last panelist is Ms. Sapna Jhangiani, who's a KC with the Blackstone Chambers, based in Singapore, with over 25 years' experience in appearing before courts and tribunals and sitting as an arbitrator or mediator in complex commercial disputes seated all over the world. Sapna has practiced in London, New York, Dubai, and Singapore, and is called to the bar in England and Wales, Singapore, and the British Virgin Islands. Sapna is consistently ranked in the leading legal directories and was recognized by the Asian legal business as one of Asia's top female lawyers. Alongside her independent practice as an advocate, arbitrator, and mediator, Sapna is also a judge in the Court of Appeal at the DIFC Court. Sapna has also been a member of the panel of advisors to the Attorney General of Singapore from the year 2021 to 2024. She was International Legal Counsel at the Attorney General's Chambers, Singapore. With those introductions, as all of you would have noticed, we have a stellar panel of people who have deep expertise in this particular field of investor state dispute settlement. I'll start with Karan, and uh, my first question to Karan concerns the recent evolution of investment treaties concerning India. As you all are aware, in the past decade, we terminated several of our bilateral investment treaties, along with certain treaties with investment provisions. We adopted a new model BIT. We sought to renegotiate certain international investment agreements. And about 3-4 months ago, there was news reports in regular business newspapers where the government said that the old model BIT, does not serve its purpose anymore, and they will be coming up with a newer BIT. Given that backdrop, Karan, may I request you to give us an overview of this evolution and how it has implications for the flow of foreign investment into the country?
So let me start by saying that it is no secret that no state or claimant likes to be on the receiving end of an investment arbitration award. So following White Industries, again, that's no secret. Uh, India did terminate around 68 to 70 BITs over the years. But with those terminations also, India sent requests for renegotiations. Now, this indicates that, yes, India also is conscious of the fact that BITs are necessary for investments. It's not that India's ignoring BITs altogether. Now, moving to the figures. In 2022, India received about 50 billion US dollars of foreign investment, foreign direct investment. But since then, the figures have gone down. In 2023 and 24, we have received only about 28 billion US dollars. Now, you cannot attribute exactly why there is a decrease, but if I were to venture a guess, it could be that today there are not many treaties in operation and investors are hesitant in investing without any treaty protection. And perhaps this is why, Abhileen, that you mentioned earlier, that the finance ministry wants to relook at the old model BIT and wants to revamp it. That said, like even the recent BIT is entered into by India with UAE, for example, still does not include an MFN obligation, does not have a FET obligation. So I'm not sure that even the new BITs that have been entered into by India also offer a substantial protection, but how this impacts figures going forward, we'll just have to see.
Thank you, Karan. That's an interesting way to start with some statistics, which actually gives you a broader overview of how treaties may affect or not the flow of foreign investment into India. Next, I'll go to Gautam, who perhaps has the benefit of having a view from the inception of treaty disputes against India and what's there the status today.
Thank you. Thank you very much, Abhileen, and it's wonderful to be on this panel. Thank you for asking, and to Shaneen for asking us to be on this panel and being in with this great list of panelists. I think the first thing to obviously state is to state an obvious point that investor-state disputes involve a tension between the sovereignty of a state and its ability to determine what it wants to do and the rights of investors. And there's an inevitable tension there. And I must also make an obvious point that this area of law has developed increasingly in the last 30 years. I remember when I was an undergraduate student many, many years ago, public international law was one of those subjects that you would not necessarily do as an option. It's obviously changed now. It's a very important subject. But the whole concept of investor-state dispute settlement is fraught with difficulties, and there's been a backlash against it as a system for many reasons. First, there's a feeling that the system is stacked against the state, that the investor has the advantage, has the upper hand, and that therefore states won't get a fair hearing and are at risk of losing. Secondly, these claims are often what we would say, a little tongue-in-cheek, as telephone number claims, where the claims are for huge amounts against states and to put pressure on the states. And these arbitrations are also public when they're filed. So there's a sense of adverse publicity being levied against the state. Thirdly, in terms of the arbitrators who deal with these cases, traditionally, and I'm going back now, thank you for revealing my age, Abhileen, but going back to the early days, it's fair to say there's been a small pool of arbitrators who were really taking most of the appointments from the early days and even now, and the group of arbitrators is small. It's drawn from a relatively small number of geographies, and there's a feeling that I call India an emerged economy. I don't call it an emerging economy, but there's a feeling that emerging economies are not getting their fair share of arbitrators appointed, and that therefore there's a lack of cultural awareness and sympathy for states like India, who are very important, but who are obviously generating lots of disputes. Fourthly, if I may say, that the process of getting an award in an investor state situation, if there's an adverse award, the annulment process in arbitration of these natures is not a very advantageous one either. Annulment proceedings are notoriously difficult to win. The hurdle to be jumped is very high. In my own experience of having done arbitrations that have gone all the way and then to annulment proceedings, we always keep a very positive side to things and do our very best. But you have a feeling, even as an advisor, that the system of annulment is stacked against the state in that sort of situation. Now, happily, we have done cases where we've been successful for states, of course, thankfully so. But there are inevitably a number of reasons, I believe, why there's been a backlash against ISDS.
Thank you, Gautam. That, in fact, and I'm grateful to you for having brought up that point, that there may be a perceived imbalance when it comes to execution of these treaties and the practice of treaty arbitrations at large. I say perceived because, well, there may always be some debate on whether it's more it serves state interests or the investors. But with that backdrop, it takes me to my next question to Sapna. Um, India, as you are aware, terminated its set of BITs and now is in the phase of negotiating new ones. What do all these newer BITs or new treaties and investment provisions reveal about India's evolving approach, and how do they compare with global reforms?
Thank you. Can I also just say how wonderful it is to be here for my first India ADR week? It's been a true embarrassment of riches of conversation and thought leadership, and I'm sure it won't be my last. So, to answer your question, Abhileen, I want to look at context, content, clarity. And in terms of context, it's really to follow on from what we've heard from Karan and from Gautam. I mean, I recall 10 years ago when India took the step of terminating almost all its BITs and it came out with the model BIT, it was seen as so radical. And 10 years on, given the direction of travel and the backlash against ISDS that Gautam mentioned, it's not that radical anymore. And if we look at the new generation of BITs that India has entered into, from around 2018, there have been BITs with Brazil, Belarus, I'm not sure how to pronounce this, Kyrgyzstan, is that right? Yes, thank you. Uzbekistan, for example, except for the India-Brazil treaty, they've all been based on the model BIT. And the one that I'll focus on in a bit more detail is the India-UAE treaty. I have long links with the UAE, and it's one that I've looked at more closely. So if we look at the content of that, I think there are differences between the different treaties that have been entered into. They are based on the model BIT, but of course there are tweaks and negotiated amendments. But it's very limiting. And I know Manish wants to talk about this because we started discussing this in the break. But there's an exhaustive list of investments. Investors will have to exhaust their local remedies for 3 years. Now, that's shorter than the model BIT. I think in the model BIT, it's 5 years. So it's a concession. But still, I'm not sure many investors want to be in the domestic courts necessarily for 3 years before they can take further international steps to protect their investment or seek compensation. You can't set up a shell company to get the benefit of treaty protection. The treaty specifically excludes restructuring to acquire the benefit of dispute resolution mechanisms under the treaty. There's a compliance with local law requirements. I think this is quite interesting. There are obligations as well as rights for investors. And I think we're beginning to see this in the new generation of treaties generally. No general protection against fair and equitable treatment. I think Karan mentioned this. There's very specific type of treatment that's covered. For example, no denial of justice, no fundamental breach of due process. There is a lot of carve-outs. And again, I think Manish might want to talk about this. For example, for measures related to taxation, right at the beginning of the treaty, you see that the parties reaffirm that each party can regulate in pursuit of legitimate public policy objectives, including the environment, health, and safety. No third-party funding allowed. We can talk about that later. And each party has to bear its own legal costs and the costs of the arbitration. So if I move on to clarity, in Singapore recently we had Singapore Convention Week. I had the privilege of chairing Lalive, and we had as our keynote speaker Martina Polasek from ICSID. And she said the fundamental purpose of ISDS is the promotion and protection of investment through legal certainty. And Abhileen spoke about the perceived imbalance that we've had in the past between investors and states. And I think what we see with these new generation BITs, in particular this one that I'm speaking about, is that there is certainty for the state, certainty as to how they can regulate. And I suppose to some extent, certainty for investors, whether it's the kind of certainty they want or not, I don't know, maybe Manish can comment on that. But you can see it's a real attempt at trying to rebalance that perceived imbalance.
Abhileen, could I?
Yes, please go ahead. Yeah.
Good afternoon, everyone. I think I just wanted to pick up on a few themes coming out of our remarks made by both Gautam and Sapna. We've of course kind of seen this backlash against ISDS manifest itself in many ways. But I think, just to be provocative, there is an argument that a lot of that backlash is actually misinformed clamor. And just to take some of these arguments, I was part of the IBS subcommittee on investment ETR arbitration, and as one of our projects, we did a broad survey of users and actually looked at each of the specific criticisms that were being mounted against RSDS. Let's take the first argument about the investment treaties being at odds with the sovereignty of states. The reality is that these treaties are a manifestation of that sovereignty. States enter into these treaties in exercise of those sovereign powers. These treaties don't typically prevent states from implementing changes to the laws and regulations. They simply regulate how states may change laws and regulations. And of course, you're trying to then balance the state's interests with those of the investors. The second, I think, aspect that we addressed as part of the IBS work was that you have a wide range of treaties with very differing substantive protections, sometimes formulated in very open terms. And therefore, you do get investment treaty tribunals under different treaties interpreting them differently in the context and in light of the object and purpose of the specific treaties. I'm not suggesting that that it's a perfect system. There is, of course, inconsistency there, but I think the solutions that are being suggested more broadly tend to conflate those two elements in terms of the substantive protections and what states can do in that regard in terms of treaty making, and the procedural mechanism, which is the investor-state dispute settlement. And I think one has to keep those two strands separate in terms of suggesting reform. And I think the third point I would make is that if one looks at the actual statistics in terms of decided cases, the suggestion that the system is stacked against the states is not borne out by those stats. If you look at all of the UNCTAD exit studies, they confirm that more cases are actually dismissed, either at the stage of jurisdiction or admissibility, and even where cases go through that hurdle and get to the stage of merits, the damages that are often awarded to investors do not reflect the full amount that's sought. So again, one has to kind of really pass the criticism. Now, I'm not necessarily apologizing as an arbitration practitioner for the system we have, but I think we need to look at the actual facts when we look at this broader backlash. It may be a bit too late because now obviously you have the UNCITRAL Working Group 3 looking at the reforms, and I think states are increasingly focused on this. But I think one thing we need to be all mindful of as people who believe in the system, a global rule of law system, that we need to really look at the facts before we throw out the baby with the bathwater.
Thank you, Manish. That's a very valuable intervention in between, just to sort of allay fears that it's not all bad and it's all not mafiosi investor state dispute settlement mechanism. But continuing with the theme of where we are in terms of evolution of our treaties, mostly concentrated towards India. Genevieve, I want to come to you. What, in your experience, have you noticed in the recent times where India has somewhat not gone its model BIT way, or the old treaties that would have protected investor interests?
Yes, thank you. And good morning, good afternoon, everyone. I'd also like to say thank you for having me. This is also my first ADR week, and it's been magical already and brilliant to share the panel with everyone here. Yes, to pick up on what my co-panelists have already said, yes, there are the new BITs that are being concluded. Again, I mean, several of them, Brazil, UAE is state. I mean, the investors don't have the right to take claims. And the same perhaps is true of TEPA. And I don't know if everybody is familiar with that, but I'm a partner at Lalive in London, and my colleagues are in Switzerland, so it's close to home for them. And TEPA is the Trade and Economic Partnership Agreement, which is a free trade agreement between India and the European Free Trade States. So that's Switzerland, Norway, Liechtenstein. And that will come into force on the 1st of October. And to pick up on this concept of foreign direct investment, I was surprised to hear that there was such a low level actually last year. And what is committed under TEPA alone is admittedly over the next 15 years, but 100 billion in foreign direct investment from those 4 states. And also the creation of 1 million jobs. Now, these are soft promises, I suppose, but it demonstrates that encouraging investors to get back involved with India in this structure is certainly on India's radar. And similar to the BITs, I mean, TEPA doesn't protect investors against expropriation. There's no FET. There's no MFN or national treatment for investments, and there's no ISDS dispute resolution. So we see a theme emerging, but even still, India is encouraging investment, balancing investors' rights against the protection of the state. And I think it's all moving in the same direction. I mean, again, picking up on this 28 billion last year. I mean, 27.8. Well, of that, 2.3 was between Switzerland and India. And I was surprised actually by that because, I mean, you can only export so many watches, but there we and chocolate. But apparently also pharmaceuticals and coming in the reverse direction, organic chemicals, electrical machinery, and textiles. So there is, this fertile ground, and I think India is doing a good job. Certainly, Switzerland, I think, is one of the maybe 25 countries that is lining up right now to conclude new BITs, and this is TEPA is a way in.
I'll just add a couple of things to what you've said. This treaty is interesting to the extent that it has both trade and investment provisions. And when it comes to the dispute resolution provision, it explicitly says that this dispute resolution is not meant for the investment chapter. And for the investment chapter, there's a consultations sort of a dispute resolution mechanism, which involves the two governments. Now, I don't know how in reality will this play out because I don't know how will investors then go to the respective governments and then the governments will consult with each other. Well, time will only tell how this plays out in reality. But continuing with our discussion and not digressing, Manish, I'm going to come back to you again. We've terminated the so-called first generation international investment agreements. Yet we continue receiving a consistent amount of FDI. Karan just shared certain numbers a few moments ago, and there is a continuous amount of investment that we do receive in India. So, from the foreign investors' perspective, how do they restructure or structure their existing investments in India under the IIAs that remain in force?
Thanks, Abhileen. And I can share some insights based on our recent experience of advising clients who are making significant investments into India across various sectors. And I think a recurring question that all of us get as practitioners is how to structure these new investments into India to benefit from the international investment agreements that now remain in force. And this is leaving aside questions of protection of existing investments under the treaties that have been terminated, because they then bring into play complex questions around sunset clauses. So we are focusing only on new investments into India and how to structure those investments. I think we are seeing two main trends. One is about investment planning. The other is around structuring of contracts, particularly with state counterparties. And let me address each of them in turn. First, in terms of investment planning, I think there is now a broader recognition that timing is key. As many of you would be aware, there is now a growing trend in arbitral jurisprudence where tribunals are showing sympathy to objections that if the dispute is already on the horizon, then structuring at that stage may be too late. And again, you see different arguments being done around abuse of process with restructuring. So I think investors are aware of that, and therefore they are treating investment planning, particularly under investment TTs, at the same time as tax planning. So that's something we are seeing in terms of the practical advice that's being sought. Then the question is, what are my choices? The reality is the menu of options now following the termination of several of India's BITs is quite limited. And actually, we recently undertook a survey based on publicly available information. There are 26 Indian treaties still in force, and those include 11 bilateral investment treaties and 15 free trade or preferential trade agreements that have investment chapters, a point that Abhileen, you highlighted. Out of these 26 treaties, only 16 contain investor-state dispute resolution provisions. And therefore, it's that menu of 16 that foreign investors, take as a starting point. Then the next question that you get asked or you have to address in the analysis is, how do you avail yourself of the substantive and procedural protections in these treaties? And again, the threshold questions that you have to consider are, would you or the entity you're going to set up for the investment qualify as a protected investor under the treaty? Again, Indian treaties have very differing formulations along the lines Sapna you highlighted. The second question is, would my investment qualify as a protected investment in the Indian territory? And again, you get varying formulations in current treaties, from a broad range of assets to definitions that now build in carve-outs and exceptions, even excluding portfolio investments in certain treaties. And the third question is, if I do have a dispute with the Indian state, would that fall within the scope of disputes in the ISDS provision? And again, you have differing formulations going from treaties that provide for jurisdiction over any dispute to treaties that limit the tribunal's jurisdiction only to disputes regarding breaches of the substantive protections. So again, you have to look at all of those factors, and then you look at substantive protections in treaties. You look at whether the treaty has carve-outs. Again, if you look at the new generation treaties, a lot of treaties, as Sapna mentioned as well, carve out taxation measures from within their scope. They also carve out subsidies from the scope of the protections under the treaty, which again can become quite relevant in terms of sectors where foreign investments do rely on subsidies offered by either the states or the center. So again, you have to consider those treaties quite carefully. From a comparative treaty contents perspective, I would say that some of the older Indian treaties that are in force offer the broadest protections. But let me highlight what those treaties are and why they're not really being used. The three most favorable treaties that India has now are the ones with Senegal, Libya, and the Philippines. They provide fair and equitable treatment, MFN, no local remedies or exhaustion requirement. But in practice, as you would appreciate, these are very awkward platforms for multinational investors, not commercially attractive, politically fragile. So you're not really going to pump a lot of money into India, through these countries, and they don't often provide you even with a favorable tax regime as well. And what that has meant is that investors have been pushed towards the newer generation treaties, one of which Sapna talked about. UAE treaty, and if you'd asked me that question 3 years ago, as a foreign investor, I would have said, route your investments into India through the UAE. It was a most favorable treaty that India had at the time. And I think what has happened now is that a lot of investments have moved towards Singapore. And it's not because the Singapore-India CECA is favorable. Actually, Singapore-India CECA is very restrictive of investors' rights. It has very broad exceptions. And again, if you're just looking at the TT content, it's not something that you would really find attractive as an investor. But I think the investors are favoring the UAE or the Singapore treaties for structuring into India, largely because of the trade ties that the countries have, and also because these countries offer you various other incentives. So I think that in a nutshell, what we are finding in practice is that even with a narrower investment TT protection package, uh, investors are still investing into India. You don't really have investors retreating, and I that's where I think, Karan, I'm not seeing that in my practice. Again, I'm not speaking, at a more generalized level. People are investing heavily into India. They're not necessarily being deterred by the fact that India doesn't have a very robust TT system in place, and they're trying to work with what's available. And in terms of what's available, I think treaty planning is just one layer. Uh, we are now seeing a resurgence of investor state contracts, even in this context, where investors are placing emphasis on contracts with bespoke protections. So, in some of our recent negotiations, we've seen a greater emphasis on stabilization provisions, on a tailored dispute resolution clauses and governing law clauses. And in fact, in one of my cases, uh, the investors sought to build into their contract all of the protections from the TT, the earlier TT. And again, I expect that we will see that kind of move back towards investment contracts, which was pretty much the norm before ISDS took over.
Thank you, Manish. That's a great 360 view of the entire sort of realm post termination of all our BITs. And I take a lot of positive from what you said. The fact that India still continues to remain an investment destination, despite the fact that there may not be any BIT protections there. We'll, of course, touch upon the fact how this impacts Indian investors who are looking at fresher pastures for investments. But I'll come to you, Gautam, with the same question. How have you seen these structuring and restructuring of investments in this post-termination phase?
Thank you, Abhileen. Manish has brilliantly summarized the position, and for that reason, and for two others, firstly, that I agree completely with what Manish says, and secondly, given that we've got a fair bit to get through, I'm going to yield my time back to you and just adopt the second and third judge in the Court of Appeal situation and say, I agree, I also agree.
Thank you, Gautam, for a very precise answer.
Thank you.
Okay, we've dealt with the fact how foreign investors have sort of recalibrated their approach to India in a post non-BIT or non-TTIP world. How do India, as I said, how do Indian companies and in-house counsel approach treaty protections when investing abroad in this realm? Can I go to Karan first and then to Sapna after?
I'm also yielding my time because I know we have a lot of topics to get on with. So I yield to you, Karan.
Hopefully, I can do justice to it. Okay, so one thing is Indian investors investing abroad are serious players. For instance, last year we had more foreign investment going out than what was coming in. And investors also are now sophisticated, and as Manish alluded to earlier, that they do know and are aware of how restructuring works. Like, for example, one of the first cases is involving corruption, the Spentex case. Now, that was a case where the investor was Indian and wanted to invest in Uzbekistan. And at that point of time, we did not have a BIT with Uzbekistan. We do now. So what it did was it restructured its investments through the Netherlands to avail the benefit of the Netherlands, the Dutch, and the Uzbekistan BIT. It did fail in its investment claim, but nonetheless, it had access to these measures and access to arbitration thanks to restructuring. Another instance of such sophistication is where Vedanta, an Indian company, has invested in India through the UK, where they avail the benefit of the 1994 India UK BITs. Now, these BITs, although have been terminated, they still have sunset clauses which span for 15 to 20 years. Now, using that BIT, Vedanta has recently launched an investment claim against India. How that plays out, we'll have to see. But the fact is, today, because of restructuring, the Indian investors are able to launch claims against India and other countries as well. As Manish said earlier, the timing and the circumstances of this restructuring is crucial. And now, as Sapna also mentioned earlier, the new BITs are consciously and expressly stating that shell companies, restructuring through shell companies is not going to be allowed, which is what was happening earlier. So earlier, what would happen is even if the investment, let's say, was restructured at the first stage, not when the dispute was on the horizon, it would be restructured in such a way that you would just set up a shell company and route the investment through that company. Now that would not be sufficient anymore. So I guess you would see more sophistication on how the restructuring is going to be done, but I see that it is going to be done.
Sapna, you have something to add, or
No, we've got so much to get through. I want to talk about the multilateral investment court later, so I'll use up my time then.
come to that. Thank you, Karan. This is, I personally was not aware of the Uzbekistan angle that you just brought in, and maybe that's what perhaps prompts a counterclaims sort of a substantive right in that particular treaty. But great, I mean, something new to learn. Now, given with all of this backdrop of newer BITs and newer investment treaties, treaties with investment provisions, in recent years, and rightly so, there has been a lot of discussions and debate on the environmental as well as the climate impact, or rather the public interest objectives of these investments at large. So my question to Genevieve on this first, what kind of investor-state disputes have already arisen in this context? What lessons can be drawn from those disputes? And do you see any of the newer BITs addressing this issue?
Right. Well, in the interests of time, that is a conversation that could take all afternoon. But going quickly and just picking up then on human rights, CSR, counterclaims. Really, there's been the specter of environmental counterclaims for maybe 15 years now, certainly with Romania in about 2011, and then the first successful claims or counterclaims made by a state in Burlington in 2017 and Parenco in 2019 with Ecuador. And in those cases, for those who aren't familiar, Ecuador was awarded around 100 million USD for environmental damage caused by investors. And since then, these kinds of counterclaims, claims by states have bobbled along. And there's certainly a way in either through the UNCITRAL rules and under the ICSID Convention, although I know that India is not a signatory. But often these kinds of counterclaims fail because either the tribunal doesn't have jurisdiction or there's no cause of action. And so how do you get your hands around that? How do you, as a state, start to protect your CSR and environmental rights? And exactly so, under this Uzbek BIT, for the first time, and I think it is unique, there is specifically a right to counterclaim and also a protection of CSR. And this sort of corporate social responsibility or human rights can span all kinds of things. Environmental, right to water, right to clean air, even the taking of property is also a human right. So in this way, I think India is getting its hands around the potential to turn the tables, if you like, on investors. And to pick up something that Gautam said, there is this perception that ISDS is entirely weighted against states. And so to allow counterclaims or to make it very clear how they can arise starts to potentially redress that balance. I mean, perhaps cynically, it's not all about protection of the environment. Perhaps it is just a bargaining chip. So as the state, instead of commencing a proliferation of local actions against the investor, you actually have a direct route in. But I mean, the Uzbek BIT is not alone in the world. So in Africa also, there's very clear under the CFTA, all kinds of rights that protect the state in terms of rights of individuals, rights of indigenous communities, protecting rights that arise on gender. I mean, I could go on, but I think there's a mood towards both counterclaims and the protection of the environment more generally.
I think that's a positive sign, because I feel that investments should have this also in mind when they're going to a developing country where, there may be lack of knowledge on this front, but if there is a provision in an international treaty, maybe there's a more responsible investment, so to say. Uh, Manish, I'll come to you with the same question. Uh, where do you see this getting highlighted in the newer BITs or the newer treaties?
Thanks so much, Abhileen. So in terms of this interaction between, uh, host states' right to regulate and investment protection, uh, you know, most of the cases that have arisen so far have arisen under the old generation BITs from the 1980s and 1990s, which don't contain the kind of regulatory carve-outs that Genevieve you've mentioned and that Sapna you mentioned earlier, which preserve the host state's right to regulate. And under the old generation BITs, you have very complex issues arising at the jurisdiction stage, at the liability stage, and quantum stage. But just to give you a flavor of the kind of issues that arise in practice, and what the states have done in the newer generation BITs to address those issues, the central kind of issue is in most of these cases is this: where is the dividing line between legitimate non-compensable regulation and a compensable breach of investment treaty protections, right? So in other words, how far can a state go with a regulatory change before it tips into a breach territory? Uh, and if you really look at these questions, what the tribunals are having to engage with is who should bear the economic burden of that regulatory change, whether it is the state or the investor. Because if you're acting for the state and act for states and investors, the question is really, I've implemented a change in pursuance of a legitimate public interest policy, and therefore, even if the investor is adversely affected, I should not have to pay compensation for that. If you're acting for the investor, uh, your argument is going to be these treaties don't prevent the state from regulating in the public interest, but I should not be the one having to bear the entire economic burden of that choice by the state, particularly in circumstances where the state offered various incentives to me to invest in that particular country. So again, that's really the debate you have in these cases, and one can obviously debate about it at the public policy level, but it becomes a question of allocation of economic burden in practice. And then, of course, you have newer generation treaties, providing for various carve-outs. The reality is that even if you look at the cases under those new treaties, and Ecuador and Colombia comes to mind, uh, tribunals are still interpreting those carve-outs in a very restrictive way. And unless states are very specific about the kind of regulatory changes that would be shielded from liability, tribunals in some cases have still found them liable for those changes. And again, one has to look at the facts of the cases to kind of find that balance. But I think the upshot of all of that is that, of course, you can have treaties, and the new generation treaties can create these broad carve-outs, but you really, as an investor or state, have to carefully look at how those are being interpreted and being applied by treaty tribunals before you can actually look at the scope of protection.
And maybe just to add on, if we take a step back, this tension that you've identified between investor rights and a state's right to regulate, I think it's one of the issues that it's at the heart of the backlash of states to ISDS, because they're asking themselves, well, this tribunal of people in professional suits, most of whom are international lawyers sitting in a conference room in Geneva or Washington, who are they to tell us about our aspects of public policy? Now, I understand, of course, they've signed up to treaties and those treaties have investor protection. But if you see it from their point of view, I think that is one of the fundamental issues that we're grappling with. And when we do move on to look at what some of the reforms are, I think it is trying to address this perception that we've got these people who have nothing to do with us telling us about aspects of our sovereign policy. I think it really goes to the heart of the debate.
Thank you, Sapna. Thank you, Manish. And I hope there is a lot of development in this sphere in the years to come. But sticking to the same question, can I trouble Karan also once again? Do you see any India-specific examples where we have to see how we learn from our past experiences and what can be done in the future?
So, one of the things that comes to mind are the Spanish solar cases. These cases stem from the fact that Spain exercised their sovereignty to regulate and reduce the subsidies that they were offering earlier to attract foreign investment. Now, this brings me back to the fact, to the something that you mentioned earlier, Manish, that how it is perceived as ISDS is perceived as being stacked against the state. Well, I don't think it's just a perception. I think it is to an extent fact. I say so because, like, if you take an example of these cases, you have similar facts in many of the cases, but the outcomes are different. Now, I agree that states signed these investment treaties and they exercised their sovereignty while doing so. But when they were, like, say, exercising the sovereignty and signing these treaties, they weren't signing away their right to regulate. And the manner in which, for example, a wide and vague FET provision is being interpreted today, that is something the states did not envision. So somehow, when a state, for example, like India, which has committed to achieve net zero by 2070, somehow today, in consonance with its international obligations, they alter their energy policies. Tomorrow, they will be susceptible to investor claims for phasing out gas production or coal production. Now, how do you balance these interests? Well, according to me, there are public policy interests that must prevail. I'm not saying that the state goes scot-free, but to avoid damages where sometimes the projects haven't even taken off is, well, open to criticism, I say. The other area where I feel India is, well, going to have going to interact with investment claims is carbon credit and carbon trading. So we haven't set up a mechanism yet, but we are in the process, and it's a new area for us. The policies that we frame, the policies, they are going to change. They are not going to be perfect, but at the same time, the Indian government must be careful because there have been claims by foreign investors against host states for change in policy in this field as well. And the recent thing that comes to mind is online gaming. I could see investor claims based on violation of legitimate expectations coming from the ban of online gaming. We haven't seen any yet, but let's wait and watch.
Thank you, Karan. I'm looking forward to that thesis after you've concluded your PhD. It'll be an interesting read. But okay, now having touched upon these substantive issues, coming back to a bit more procedural issue and which kind of affects the substantive at large. Um Last year in the month of February, the expert committee on reform of Indian arbitration law recommended a separate legal framework for investor treaty arbitrations. Uh, they raised concerns about third-party litigation fundings and supported the creation of multilateral investment court, which has been going on and has done a lot of round of discussions at the UNCITRAL Working Committee 3. Uh, Taking these issues one by one, Gautam, I'll first come to you. How does the world of third-party litigation funding and ISDS interact?
Thank you, Abhileen. I'll try to be really brief if I can, just mindful of time. Third-party funding is here to stay. It's a demand and supply issue. And there are rightly some ISDS claims that are proper and should be brought. And let's not forget that third-party funders are business people. They do their due diligence very, very thoroughly before they take on cases. It's a long process. Okay, they'll take multiple legal opinions on the merits of a case. They'll want to know the ins and outs of a case. So I don't subscribe to the point of view that third-party funding is bad. I know, of course, that there was criticism that the Panthera claim against India was funded by a third party, but there it is. You're never going to please everybody. Third-party funding is a product that's there to be used, and it's only right that where there is a good claim, and like I said, there'll be thorough due diligence before a claim is brought, that third-party funding may well be the reason why a claim is brought and why it's not just left to one side. So let me yield back some time to you.
Thank you, Gautam. But just to tell our audience, the funding which has been raised for that case is about $14 million. So it's not exactly a cheap exercise conducting these sort of arbitrations.
Investment arbitration doesn't
is
tend to be cheap.
Sapna, coming back to you.
Two quick points
yes.
on third-party funding and investor state arbitration. First relates to the appetite for third-party funding and investor state arbitration. A friend of mine is a chief investment officer of a large global third-party funding firm. And the impression I get from discussions with him is they're not that interested in investor state claims anymore because, of course, they're very unpredictable. As Karan said, if we look at the new generation BITs, there's a lot of carve-outs. Investor protection is limited. So a lot of the cases we see and have seen are the older BITs, which are quite vague. As you say, I mean, it may not have been anticipated that this would be the way that disputes would evolve. And so the outcomes can be really unpredictable. And I think third-party funders have discovered that the hard way. So I'm not sure I'm not saying we won't see third-party funding of investor state arbitrations. I'm just not sure it's their priority at the moment. And the second point is just to agree with Gautam, I think they get a bit of a bad name. My own experience with third-party funders is actually they tend not to interfere with the process and they're really keen on settlement, which can be quite a good thing. They want to eliminate the risk and that can also be good for clients.
Can I just say also, I think what sticks in the craw of the populace is that the multiple that the funders get. So they may be spending 14 million, but they are doing that on the basis that they will cover 3 times, 5 times multiple. So it is a gamble, certainly, and they do it in an educated way. They don't interfere. It's very sophisticated, but I think, especially if you are a citizen of a host state and you know that not only is your government going to be paying out 100 million, but they're paying out a quarter of that to this nameless, faceless corporation who didn't deserve it. That doesn't sit right with your man on the street.
Yeah. Hence, India, UAE, BIT, every party pays its own costs, no third party funding. You can see, and I wonder if we'll start to see more and more of that.
We actually, I think even in the India Uzbekistan BIT, there is a prohibition on third party funding. I think we'll have to then kind of see in practice how the term third party funding is interpreted. Because you often have these claims brought in corporate chains funded at different levels. So I think something to watch out for.
That's an interesting thought, Manish. Sorry, Genevieve, you don't need to put on your mic. I'm coming back to you again for your views on multilateral investment court and how does that play into India's evolution of its modern day BITs. Yeah.
Gosh, well, in the 45 seconds that I see on this screen, I think that will be a difficult one. And Sapna, you might want to jump in as well. But I think multilateral investment court as an alternative to ISDS is something that has been in discussion for at least a decade. And yes, to pick up on, as Gautam said, perhaps there's a perception that developing countries, and to the extent that India is perceived as a developing country in the arbitration mafia, that they still don't get a fair shake at ISDS and might not get a fair shake in a multilateral investment court either. Also, and mixing in 7 seconds, mixing topics, the idea of appointing judges to a multilateral investment court is still politicizing the process. So is that actually an improvement on ISDS, despite all of the benefits that perhaps an MIC could bring, like transparency, like consistency? Sapna, do you want to?
I mean, I think there's two lenses through which to look at this. First is a conceptual lens. How are we going to appoint the judges to make it fair? Who's going to pay for it? These are all the issues that are being talked about, worked through Working Group 3. A lot of resistance to a multilateral investment court. On the plus side, there would be certainty, consistency, a theme that we've been talking about a lot today on today's panel. The second lens I want to think about, though, is the practical lens. The EU, as we all know, is very keen on the multilateral investment court. If you look at their latest agreement, so for example, the EU-Singapore Investment Protection Agreement, what it provides for is mediation at any time, and also for an ad hoc court to be set up, a third of judges Singaporean, a third from the EU, a third neutral. And my practical point is this: if the EU, which is a big block of countries, has a lot of negotiating power, if they're going to be entering into more and more and more of these treaties, one wonders if there will be some momentum built. And if we're looking at the type of instrument that's being discussed in Working Group 3, which is a multilateral instrument, you opt into things, you opt out of things, I wonder if we'll see the momentum grow and it will start to make more and more sense for more and more countries, maybe instead of having an ad hoc investment court in a bespoke agreement, to start opting in to whatever already exists. So I just wonder if there is a practical way that this will all evolve that might be very different from the conceptual obstacles to the court.
Just a couple of quick reactions, if I may, to that, Abhileen, to what Sapna and Genevieve have rightly said. I must say, and again, not to be provocative, I just can't see it happening. I know it's been talked about, and I'm not going to repeat the arguments for and against. I just think it's just too much of a prickly issue. And indeed, India has already said it's not going to accept a multilateral in a court. So, so some countries, and there are other countries too that have publicly stated this. And the real concept is also about just how do you make it fair? I mean, it's just, and also understanding the issues and all. I mean, there's so many difficulties with it, and I just don't see it happening. And also, dare I say, the arbitration mafia that currently deals with these sorts of cases is going to be a very big rock to move, right, in terms of that stuff. So I think for all those reasons, I remain very skeptical about the concept.
We should have a bet. We should see where we end up in 20 years.
So we've been allowed 5 more minutes, and within this last 5 minutes, and I'll go to all the panelists. I'll throw this open to all the panelists. In this backdrop of whether an investment court is a viable option or not, um, how do you see the scope of other forms of dispute settlement, and how are these mechanisms working in place if they are, from your experiences? So, I mean, I can start with maybe Manish and then Sapna. Would you like to contribute after?
I think in terms of alternatives to investor state arbitration, if you look at most of the treaties in force, they already have built into them a cooling off period, typically 3 to 6 months, where the state and the investor can explore an amicable resolution of the dispute. And what we are seeing in practice is a greater strategic use of notices of dispute or trigger letters, where an investor can use those notices to internationalize the dispute, to get more political attention than a purely domestic dispute would get, to explore whether the state would be willing to settle the dispute while preserving the arbitration option. And in that context, we are also seeing a lot of discussion around investor-state mediation, which can facilitate solutions that can combine both financial and non-financial elements, particularly kind of tweaks to the regulatory changes, which obviously you can't achieve in practice in an arbitration. So again, I think that's a trend that's beginning to emerge, and one that I expect to continue.
There's tons of work being done to encourage the use of mediation in investor-state arbitration. Just for example, ICSID are doing lots of training on this. They've got their new mediation rules. It's all great. We still have all the obstacles to the use of mediation, ISDS, which is, for example, accountability. People want a piece of paper to pay against. And one of the options that I think we should see more use of. Now, you will recall that before ICSID had these new mediation rules, it had conciliation rules. One of the problems is not many people understood what conciliation actually meant. What it actually means is a non-binding neutral evaluation. And I think that it's great that we've got all this focus on mediation now, but I wonder if we now need to start telling everybody what conciliation is. It's still around, there's still a panel of conciliators. Maybe we could see more use to address this problem of accountability, more use of this conciliation mechanism, some kind of neutral evaluation, which can be taken back to a state to sign off on whatever mediation or whatever settlement can subsequently be agreed after the conciliation. You could have the neutral evaluation as just a starting point for negotiations. There's all kinds of creative options out there. I think we actually have more work to do in that area. Mediation is still great, but I think we need to find a way to combine it with neutral evaluation.
Yeah. Karan, Genevieve, any final thoughts on this before we go to the audience for a couple of questions?
I think I'm gonna pass on this one. I don't want to keep people from their lunch.
Any questions from the audience? We can take a couple of questions. There's one. Yeah, there's one. Yeah. Please, sir.
Quite interesting discussion on the bit. Yeah, the investments into India. I feel that the few reasons which could be after the change in the 2016, that investments getting into India have become easy and difficult. Both the things have taken place. To tell you, like some of the very stunning things are right from the time of 2000, when the Enron case, where power was supposed to come into India, like flowing into India, has been, made a stumbling block into that. That's a big arbitration case, one of the largest one into the India. Then comes to the Vodafone, where the retrospective taxes.
So may I just request you for your question to the panelist in this one?
Yeah, so I have to, precursor should be there, otherwise I can't ask the question. So like that, if you see that there are several other companies which were having hurdle. Like when you see the foreign direct investment into the stocks and all, where the long-term capital gains and all, which was very hostile, and they were taking off. FDIs were moving out. That's how the things of the investments into 2023, 24, post pandemic had come down with this long-term, capital gains. So now the question is that with this kind of, changes and all, and with having such uncertainties when it comes to the settlement of the legal disputes and other things, how do you think that these we can see in the future, as how you are giving the things, that there'll be a good amount of flow into India from the foreign companies?
Is the question addressed to a particular panelist, or I can anybody?
Anyone can answer.
Yes.
All are experts. Anyone can answer.
So I will say this: it all boils down to governance. If you have clear and transparent governance, I think investment is automatically encouraged. I'll give you an example. For example, Brazil, its investment treaties do not have the traditional protections that you find in other treaties. But still, it is the fifth most, well, rather, foreign investment wise, it's the fifth country which is receiving the most amount of FDI. And that is despite the fact that there are no treaty protections, despite the fact that there is no treaty arbitration. So from 2019 till 2022, 24, the foreign investment just keeps going up. Now, that cannot be attributed directly to the fact that there is arbitration or no arbitration. It's all, according to me, boiling down to governance, because the investors are still encouraged, because of the system, the legal system as well, to come in and invest. So I guess if we get that act together, ISDS or not, I think we should receive our due share. Thank you.
There's one more question right behind you, and that's the last one.
Hello, James Nicholson, FTI Consulting. Investors like certainty, and we've been hearing from the panel how the current ISDS system doesn't really give them certainty in outcome, and it's expensive and time-consuming and risky to engage, and we've all seen that. So actually, the move or the potential move to investment contracts is often raised as being a bad thing, but is it potentially a good thing because it gives investors more certainty? They can say, okay, we know what we're investing in. We know Spain's not going to cut the feed-in tariff for 20 years, or we know Spain might cut the feed-in tariff because it's explicitly in our contract. And the states get certainty as well. They've made explicit promises rather than slightly vague, uncertain promises about fair and equitable treatment in centres. So should we welcome the move to a potential move to investment contracts? That's to anybody on the
I think
panel.
we concur. Everyone seems to be nodding. By the way, I'm so sorry. I should have mentioned any comments I make today, of course, were in my personal capacity and not in the context of any of my official roles. I was meant to say that and I forgot. But I concur. I think Manish does. We're all nodding.
Yeah, no, I think we would agree with that, James, as a conceptual point. The difficulty is that there are many sectors in which you can't really enter into contracts with states or state-owned entities. And I was involved in 10 of the Spanish cases that Karan mentioned. I do have different views on that, but I won't go into that. But I think the reality is that even where investment contracts are an option, quite often the state counterparties insist on governing law provisions and dispute resolution provisions that do not give you the same level of protection that you can get under an investment treaty. For example, having a dispute seated in the host state, subject to the supervisory jurisdiction of the courts of the host state, is not going to really give you that kind of a neutral evaluation of your dispute that you're looking for in an arbitration context. So you're right that of course you achieve greater certainty, but then I think it really comes down to negotiating power with those state entities. And the reality is that state entities are now a really big kind of part of the arbitration market, and or generally as a really big commercial players, and they do tend to have greater bargaining power. So you don't always achieve what you would otherwise hope to have in terms of investment treaty protection.
Thank you, Manish. With that, we'll close this discussion. Thank you to all the panelists. This has been a great round of discussion on India's evolving treaties. And thank you, audience, for a patient hearing. Thank you.